Welcome to Advocates of Justice Paralegal School. We provide the tools, you guys do the work. I'm rolling from the farm today. I'll hear things in the background. It's because we're on the farm. So you may hear some cows. There's a young kid playing basketball off in the way over there. Welcome to Advocates of Justice Paralegal School. I'm Coach Neighbors. Today we are going to talk about the reasons why you have no rights in foreclosure court. I'm going to review a few of those reasons that you have no rights in foreclosure court. We're going to review some of the reasons why the judge has conflict of interest and cannot rule in foreclosure case. We're also going to cover some important facts that you need to know when you amend your lawsuit. But before we get started, I want to take a minute to ask you guys to please let's just get rolling. The reason why you don't have any rights in foreclosure court is my opinion based off of all the work that I've been doing for the past very long time. So you have no rights because you're in an administrative court process. And the way you can tell if you're in an administrative court process is because the statute that they use to drag you into their administrative court process is not a valid law. The foreclosure statute that they use for judicial foreclosures is not a valid law. It's missing the enacting clause, it's missing a title, it's also missing a body. Those are three things that your state constitution mandates must be present in order for something to be a valid law. And it's not a valid law. So that makes it an administrative proceedings. Now, here's one other reason it's an administrative proceedings. And I'm thinking most people can relate to this. The other reason it's an administrative proceeding, and this is the reason you can prove it's an administrative proceeding, is because you have no constitutional rights. You have no constitutional rights in an administrative proceeding. Their administrative court is not connected to the Constitution, and you have no rights, and that's why they don't give you any rights. What we are doing is suing them for violating your due process with their administrative procedures, and that's working out very well for us. Now, the non-judicial process is also an administrative procedure and violates the Constitution, because the Constitution mandates that you're supposed to have due process before they take your stuff. And that's not what they're doing right now. In my opinion, the non-judicial process was put on the books for these attorneys to have an option to process the foreclosure on when people pack up and move out. And then people they figured out we don't know shit, and they just started using it for everything. And if you do your homework, the evidence that you find will support that. I can tell you the non-judicial process is an administrative process also, because think about this. There is no way in hell they could sell your house on the court steps in 30 days after they demand their payment if they didn't already have a file and already have your court and already have, yep. And a lot of times when you get served the lawsuit or the eviction paper, whatever, there's a stamp, they stamp a barcode at the bottom. And in my opinion, the numbers on that barcode reflect the administrative file. And we always put that on our paperwork. Just get down to some juicy stuff. The reason why the state court judge does not have jurisdiction to rule in foreclosure case. And I love this part. Now, we use this to jam them up when they're trying to kick you out of federal court and make you go back down to state court. Remember this. And this is important to remember in your strategy, because it reinforces the fact that you can't wait for the judge to help you if you haven't figured that out already. If you haven't figured that out already, you probably shouldn't be in this program. I'm just saying. The reasons why the state court judge has conflict of interest to rule in a foreclosure case is because the state committed real estate deed fraud when they failed to deliver your deed as mandated by the state law. The state law mandates on real estate transfer law mandates that your deed is supposed to be delivered to you, and it is not. They did what they call their constructive delivery, and they registered the deed in their office, and that registration of the deed allowed the very first illegal lien to be placed against your property. Most people don't know that that first illegal lien was the mortgage lien. And here's why. If there were several people that own property before that property, a lien to be taken out of that property, everybody would have to be there to sign, right? Well, the fact that the alleged lender accepted your signature on the mortgage lien proved that you owned it already. So there you go. I believe I bought a box. Two things that not smart people do. So we have to keep it simple. No, really. When you keep it simple, it alleviates the arguing, because if you haven't figured out by now, you should figure it out. Their system is structured for arguing, and when the arguing's over, everybody just help them. So, bam, it's that simple. So if you go in with stuff they don't want to argue about, then everything is you're going to put yourself in a little bit different situation. The state committed real estate deed fraud by failure to deliver your deed to you. And that is the beginning of now. The reason why, I know I'm going to get to it, the reason why the state judge has no conflict of interest is because the state judge is being paid by the state. The state is the one that has control of your property deed. The state is the one that's actually foreclosing on you. It's not the lender and it's not the attorney. It's the state. The state is the one foreclosing on you. They already have your original property deed. They just need to get your ass off their property. I'm just saying, think about it. The state is the actual party that's foreclosing. And the judge is getting paid by the state. So if the state is the one in control of your property deed and the one that's foreclosing on you, and the judge is the one being paid by the state to make the fair call, oh, do you see where I'm going with this? And this is why we add the state judge to the foreclosure process, even at the beginning. If you're in a judicial foreclosure, we add the state judge, because the state judge don't have anything on the record that would allow the state judge to have judicial authority. The state judge does not have jurisdiction. There's no inter party. There's no original contract. No account of the money trail. There's nothing. There's just a stupid promissory note signed by one person, the alleged borrower. Oh wait, the bank vice president did sign it after you left the table, and they stamped paid to the order of on it and turned that promissory note into a security and processed it through the Federal Reserve. That is the actual source of the alleged loan that they're saying they made you. So they did not make you a loan. What they did was act as a money exchanger and exchange your promissory note for electronic credit. So the state judge has conflict of interest because the state judge is being paid by the state. The state is the one that violated the real estate deed law and compensated your original property deed and is in control of it. Now, I have a package that I put together to challenge the property tax. You know, that's what I call it. But actually, that package is structured for you to get control of your property deed. Now, this is what I've been telling people, and this is what we've been doing. When you get them backed against the corner, then you need to let them know that this could all go away if they deliver your property deed as mandated by the state law. You don't have to go and get the property tax package. This is all about getting control of your property deed. I don't care if you were in a foreclosure, eviction process from foreclosure, if you're in a tax lien foreclosure. None of those words matter. What matters is they're attacking your property and trying to take your deed. Well, they already have your deed. They're trying to get your ass off their property is what they're trying to do. So when you get yourself in a position to negotiate, then you want to make sure that I know we got 5 million, some people at 20 million. We're not after the money. What you're after is the opportunity to stay in your damn house. That's what we're after. And that's it. And then maybe you can take a shot. But at the end of the day, you have to stay focused. That is the reason why the state court judge has conflict of interest. Amending your complaint. We're going to talk about this for a second. I want to keep this short so people can remember what we're talking about today. Amending your complaint. You guys must go and review the Federal Rules of Civil Procedure, the section on amending your complaint, and learn what it takes to amend your complaint. When you amend your complaint, according to the How to State a Claim videos, you want to add all of that you put together from How to State a Claim in on the top of what you already have, so that you still have what you invested in. Because the whole idea is to let them know what you know, because you don't want them to drag you into court, or you don't want to have to drag them into court in the end. Go and learn the rules. Now, what I did with my sister's case is we didn't learn the rules before we filed. And when they complained, we went and learned the rules. So, we're learning how to do this. I'm telling you guys, it's better to learn the rules first. And then that way, they're still going to complain, but at least you they're going to have to find something the hell else to complain about. So, so that's what we're going to do. What we did was we requested the court accept our amended complaint as a supplemental pleading under Rule 15. I think 15C something. We did that because we added the attorney who signed to represent the other attorney that we're suing. The attorney who signed to represent the other attorney that we're suing in federal court, we added him to the lawsuit in federal court, and that attorney has not passed the federal bar or have license to be in federal court, and they're allowing all of this. So we put the court on notice with our notice of claim that the court is violating our due process rights. And then the court the court construed the notice of claim as the demand for judgment. So the attorneys were rushing around responding to the demand for judgment when all it was a notice of claim. So obviously they were working to get together to figure out a way to try to get it shut down. So we just went back in and we removed the notice of claim from the record. Because the court misconstrued it as a demand for judgment. And here's the thing with my stuff. I like to teach people how to punch them and punch people in the face until they give up. So I'm not demanding, well, actually we are. We're demanding a judgment on the $50,000 sanction motion that we filed. And that's what we told the court. We'd love to have a hearing on that. We've only asked 3 times. You want to make sure that you figure out how you're going to present your amended complaint. And, it's interesting because the attorneys we need to dismiss it. Well, the rules clearly state that whenever you request for amend, it should be freely given unless you're an idiot. Actually, you should get one pass without a question. So these attorneys want to dismiss. They're complaining because I didn't ask them first before I did the amendment. And I'm sure I know how that's going to go because we're kicking their ass bad. No, they're not going to agree to nothing. Are you kidding me right now? So at the end of the day, they don't have shit to do with it. And the way I see it, if they're moving to dismiss your claim for your lawsuit for failure to state a claim, then you need to amend it and state a claim. So pretty much what I put in there is that seemed to be the next order of business. I don't have time to sit around and wait for the court to give me permission to amend it when it says right in the rules that it's freely given. So I think they're a little jacked up. They did not realize that we were going to amend it or that we knew it, and we jammed it in their face the way we did. We figured out how to state a claim the way they like it, and now you guys need to learn how to do that. So they won't be able to be whining about. They'll have to find something else to whine about. If you add things to it, you might want to think about adding a supplemental pleading. And usually if they do hire an attorney to help them, then I would add that attorney to it to make it a supplemental pleading. And then that way you can, you guys read the rules. You read the rules, you'll figure out how you need to do that. And make sure you study the videos on how to state a claim. Thank you guys for spending the time to watch the video. I appreciate the opportunity to share time with you. And I will see you guys in the next video.